Good morning, everyone, and thank you for the floor. First of all, I would like to extend Dr. Gyprianou's apologies for her not being here today. Although she's honored by the invitation, unfortunately, a prior professional engagement requiring her presence has kept her from joining us. For that reason, I will deliver this address on her behalf. Honorable members of the judiciary, esteemed professors, dear colleagues, and participants. One could not think of a more opportune moment for the organization of a conference on the challenges to judicial independence and liberal democracy than the present. In this respect, I must congratulate the Procedural Law Unit of the University of Nicosia and the International Association of Judicial Independence for this initiative. The program of this conference is impressive. It creates a unique setting where views will be expressed and exchanged among specialized academics, experienced judges, officials, and practitioners, including those directly involved in the project of the ELI Mount Scopus Standards on Judicial Independence. The diversity of the participants, all of high caliber and expertise, accounts for the stimulating discussion that will ensue. The Mount Scopus standards have come at a time when the democratic deficit is a matter of concern and raised all the more frequently in public discourse in Europe. The potential effects of ongoing challenges to democracy, including misinformation and corruption, on the administration of justice and to what extent justice systems can safeguard their autonomy in a highly polarized political and social environment, are pressing questions that we should not shy away from. Recent case law of the Court of Justice of the European Union has highlighted both the challenges to judicial independence as well as the role of judicial independence as a central tenet to the principle of the rule of law, a founding value of the Union. Therefore, the function of the Mount Scopus standards as a tool, or compass rather, for the safeguard of judicial independence is key in guiding justice professionals in Europe. As it is stated expressly in the fundamental premises of the standards, judicial independence is not a personal privilege of judges, but it exists to serve the social ends of the right to fair trial, respect for human rights and fundamental freedoms, and an efficient and fair legal system. This furthermore enhances accountability of judges. The standards cover a wide range of significant matters, including impartiality, merit, ethical standards, and disciplinary procedures. This demonstrates the complexity and multiple facets of the subject. During the next 2 days of the conference, we will have the opportunity to discuss the practical implementation of the standards, placing them in the context of current political reality. What is more, we will look at these issues from a global perspective, with speakers addressing the matter in relation to various jurisdictions, including Cyprus, the European Union, Eastern Europe, Switzerland, and Latin America. A comparative approach to global legal and ethical questions brings added value to the discussion with prospects of truly fruitful exchanges of views and outcomes. One more perspective I would like to highlight as an attorney of the Republic is the value of the Mount Scopus standards for prosecutors. As Vice President of the Council of Europe's Consultative Council of European Prosecutors, I note that there are visible common denominators in the expected standards for judges as well as those for prosecutors, who are encumbered with the task of acting on behalf of the public interest. I quote for that matter the explanatory note of the Rome Charter adopted by the CCPE on the norms and principles concerning prosecutors. The independence of prosecutors is not a prerogative or privilege conferred in the interest of the prosecutors, but a guarantee in the interest of a fair, impartial, and effective justice that protects both public and private interests of the persons concerned. For these reasons, during the last high-level conference of the CCP in July, we discussed functional and operational independence of prosecutors, including mechanisms to protect prosecutors from undue influence, especially in high-profile or politically sensitive cases. Consequently, I strongly believe that the standards are a source from which we may draw guidance and inspiration on a wider level in the field of administration of justice. I would like to stress also that the development of standards for judicial and prosecutorial staff goes hand in hand with continuous training, research, and professional development. From this viewpoint, the Academy of the Law Office, of which I am the head, has placed particular emphasis on ethics, advocacy skills, and other professional forms of training in collaboration with other stakeholders, including universities, the Bar Association, and the Cyprus Judicial Training School. Honorable members of the judiciary, esteemed professors, dear colleagues and participants, the principles of democracy, the rule of law, and human rights on which the international community, the Council of Europe, and the European Union are founded have acquired an even greater significance today. International challenges, the use of modern technology in public discourse, and the intensity with which public dialogue is carried out bring about important challenges to notions that were for decades considered irrefutable. In this respect, justice, both as an institution as well as an ideal, is and should remain a stronghold for the protection of citizens and society. Further enhancing its autonomy, independence, and impartiality is of essence, and the Mount Scopus Standard's contribution to this goal is invaluable. Consequently, I would like to congratulate the organizers once more for raising this issue in the framework of this event and wish all the participants a productive conference. Thank you.